Immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions, and I have a good topic for you today. So, what do you need to remove the conditions on your 2 year green card? That is the topic that I'll be talking about and addressing today. Now, when you get your 2 year green card, I know you feel like, wow, I have accomplished quite a feat, and some of you may think that's going to be the end of the road. Hi there, Pretty J. And you can relax for a while. It's 2 years, but you may not understand after the 2 years, what do you need to do? So I'm here to talk to you about that whole process. Now, for those of you who you don't know what this 2 year green card is versus the 10 year, let me give you a little education on this first, and then we'll talk about what you need to go. And we call it, when you're going from a 2 year to a 10 year, we call it removing the conditions on your 2 year green card. So, when you are married to a US citizen, so you go through the marriage based process, you may be outside of the United States or here in the United States. At the time that you get approved for permanent residence or the immigrant visa, if it's under 2 years, you've been married for 2 years or under, it means that you're going to get that 2 year conditional green card, conditional permanent residence. And it's sort of, I like to describe it as a probationary period. You get to do everything like a permanent resident, except that the card itself is for 2 years. And so at the 1 year and 9 month mark, you can start to make a move to remove those temporary conditions to turn it to a 10 year green card. So it's very important in that time, that probationary period, that you are still gathering the evidence you need with your spouse, or if you're no longer with your spouse, make sure that you understand what you need to move forward to get the 10 year permanent residence. You can move forward. So usually they do require you to apply for the to reply apply to remove the conditions on your 2 year to get the 10 year with your spouse. You are required to file jointly with your spouse. So that's the other difference, is now you're no longer seen as the applicant. It's going to be you and your spouse that are signing the same document. It's called the I-751 form, to go ahead and prove that you're still married, you're still a bona fide couple, so that you can get the 10 year. Uh, and so a lot of people, when you do have problems, because some marriages, many marriages, I have seen that the divorce rate is like 50%. And so many marriages are not going to make it through this. And it's at the point where I think a lot of people, when they feel like the marriage is not working, they feel distressed because they feel like, no, their whole future in the United States is at stake because the spouse may not apply jointly with them. That this is not necessarily true. You can still apply on your own if you do qualify under the criteria, the eligibility criteria. And I'll get into that. But if you're married, you're still moving forward with your marriage, and you get to that point where it's time to remove the conditions, you will have to jointly apply. Another thing is, there is a difference between updating your green card, renewing your 10 year green card, and removing the conditions on your 2 year green card. Don't confuse the two. I have seen this before, where an individual filed what's called an I-90 form to renew the green card, and then found out later that that was a whole wrong form, and they wasted a year of their time and money filing for this wrong form. Whenever you're filing, going from a 2 year conditional green card to a 10 year green card through the family or the marriage based process, it is going to be the I-751 form. The I-90 form is for those who already have the 10 year, and they're going ahead and they're renewing to another 10 year green card. So that's just a little side tidbit there. But once you're ready to go ahead at 1 year and 9 months after you have been granted permanent residence, you're going to be allowed to apply to remove those conditions. At that time, you and your spouse should gather all the evidence that you've put together in the last 2 years. So, another mistake with these types of applications that I see is people tend to take the same exact evidence that they had at the time that got them approved for the first green card, so got them approved the first time. They'll take that exact same evidence and then just send it all back again to get the conditions removed on the 2 year to change it to the 10 year. This is a big mistake because they're going to not accept this. What they want to see is evidence of your bona fide marriage, evidence that you both continue to live together in the 2 years since you got your permanent residence. So, from the date you got your permanent residence up until the date you're applying to remove the conditions, they want to see new evidence. So, I'm going to give you an example of the types of evidence that they're looking for. Now, at the time that you are now a permanent resident, you're now living happily ever after with your spouse, or maybe not happily ever after because marriages don't necessarily, they're not perfect, right? So, but you're living with your spouse, you're going to be doing things with your spouse, right? You're going to be now you have a social security number, you have your permanent residence card. So you have a lot more flexibility. You can travel outside of the country together. So you're taking trips together, maybe around the country, outside of the country. You are filing taxes together because now you're a resident and you feel confident in your ability to have your job and file your taxes together. In some cases, your tax person may advise you not to file joint taxes. It depends, but most couples do file joint taxes together. And then they have their joint lease, or they have a mortgage together because now they've purchased a home, or they've definitely moved into the same place. So at least a lease. They may have started a family, so there may be a baby between the both of them that they can show that they've had a child. So all the things that have happened in that 2 year period will be very important evidence to show that you are continuing to live in a bona fide marriage with your spouse. So at the time that you jointly file, you want to make sure that you are within the deadline. If you file after the deadline, you could be in trouble, because you usually have to have a very good reason for why you did not file by the deadline. And the deadline, so you're allowed to start filing 90 days before the expiration on your card. If it passes the expiration on your card and you haven't filed, not that it's not too late. You can always still go ahead and submit it to the USCIS with a good reason why you missed the deadline, and they could very well likely accept it. However, I'm not telling you to do that. This is where you need to make sure you're represented. Representation matters, because you don't necessarily have the legal know-how or expertise to understand how to navigate these issues and to avoid sticky problems in this process. However, if you do miss the deadline for some reason or the other, don't give up. Don't throw your hands up in the air and say, I'm just gonna go back home then because I all hope is lost. I've missed my deadline. Don't give up. We have submitted these applications after the deadline with a good reason for why they missed the deadline, and it has been accepted. So, and then both you and your spouse have to sign the document, right? So it's called I-751. Yes, I see a question here saying, is there a cost to file that? Absolutely, they do have a filing fee. Right now it's $680, but it is going to go up. So they have proposed to increase filing fees next month, and so it's going to probably be increased. I'd have to check the chart, but it could very well be a different fee soon, but there is a filing fee to do that. Now, what about the situation where you are no longer with your spouse? Maybe the marriage didn't work out. Um, are you able to still go for your 10-year? And this is my simple answer. Absolutely. You are. You're able to still move forward if you can apply for a special waiver. I do assist clients to go through this process, and I've assisted clients to navigate it successfully, especially when it has come to complex issues like this. Um, Now, in this case, you either have to show divorce and that your marriage is bona fide. You have to show divorce and that your marriage is bona fide. You have to show that you were mistreated by the spouse and that your marriage is bona fide, or extreme hardship if you have to go back. Excuse me, I'm still the cold is still lingering, so excuse my coughing. I still have to be here, show up for you guys, but so please excuse the coughing. It will go away soon. So yeah, so now in this case, another good advantage of applying on your own in this case, if you're going to look at the bright side, is that you are able to apply for it at any time. So, say a year after you got permanent residence, things didn't work out and you got divorced, then you could start applying to remove the conditions with that divorce waiver a year after. You don't have to wait for the 2-year deadline. So that's one advantage. The other advantage, of course, is that when you have a spouse that is mistreating you, for example, or you're just not getting along, they're no longer involved in your process. So this is your process and you're in control of your process. With my help, clients have embraced this, and they've taken comfort in that rather than being distressed about it. It's brings relief to know that you don't have to depend on someone that you're separated from or that they're mistreating you. Another thing is when you're applying for this based on mistreatment, it is extremely confidential. So they do make sure that they don't disclose your information to anyone, and they review all your statements and evidence that you have regarding the mistreatment. Another thing is, say you did not apply because of situation like that. Say your spouse was giving you a hard time and the time to apply passed by already. The good news is that you can apply for this waiver anytime before the deadline and also after the deadline, as long as you don't go to court. If you go to court, because this is it, right? I know the next question is, well, what if you don't get the conditions removed? What's going to happen? Well, eventually you will get a notice to appear in court for deportation. At that, you never want it to go that far, because when it does get that far, it means now it's in the jurisdiction of the court, meaning the immigration court is in charge of it now. And so this will not be considered by the USCIS unless it's kicked back out by the court. So it becomes a very complex process. I did have an individual who I advised 1 year before this happened. I could predict to her that if she did not get this right to apply for the waiver, she would go through deportation proceedings. And she dragged her feet until she got that dreaded notice in the mail. And at that point, it's more expensive, it's more nerve-wracking, because now if you go to court for deportation, if that judge does not grant you the waiver to remove the conditions, they're going to deport you, right? Unless you have some other form of relief, you're going to be deported. You're going to have to go back home. So you're in a position where you have your 2-year green card. You have the ability to apply on your own. And furthermore, even if the deadline has passed, it's not too late. You can still move forward with applying as long as you don't get that notice to appear in immigration court. And you want to avoid that by all means, because nobody wants to go through that expense and that stress. And the expense is a personal expense as well as a financial expense. So just keep that in mind. Now, if you are at this point right now, you're listening and you didn't apply because you are afraid to apply without the spouse or you didn't know how to do it. Now is the time to get in touch, speak with me so we can get started to get it in and get things fixed right away. um Now the process, now I think once you apply because the other thing I've heard or question I've heard is, well, some people will say I can't travel now because the deadline has passed. um you can travel as long as you file the to remove the conditions. You are going to get an extension letter. Right now, they're issuing a 48-month extension letter that says that you continue to be a permanent resident for that's 4 years, 4 years, or until they make a decision. And even if they deny your removal of conditions application, you are still considered a permanent resident until an immigration judge takes it away. So I want you to walk away with this. As long as you haven't gotten a deportation order from an immigration court, it's never too late to fix your situation, and you are still able to show that you're a permanent resident. What we do is, if you're in a situation where somehow your time has passed, you feel like your status is expired but it's not, what we do is we schedule for our clients to get an I-551 stamp to be placed in their passport to continue to show they're a permanent resident, and they're entitled to get that right up until the point, we would hope not, but the only way that they stop being a permanent resident is if an immigration judge takes it away, right? So it's never too late. With this 2 year to 10 year, never assume that it's too late. But once you get a deportation order, at that point, it means that your permanent residence has been revoked and you're going to have to fix that situation. Um, So you can always go ahead, get in touch with me. Let's talk about your particular situation and see if we can get you from the 2 year to the 10 year, whether you're with your spouse or not. It's always best to at least get legal advice and representation. It does make a difference. This process here is taking many years. It's taking 2, 3 years to get through it, and it's taking that long as well. It's taking long enough where there are no mistakes or no errors. But if there are issues where they have to issue a request for evidence or a notice of intent to deny, that means that you're also having to go through a lot more stress. So always know that you're free to call and schedule an appointment, and we can talk about your issue and then get right on applying for removing the conditions, whether you're with your spouse or you're not. All right, so that's it for me. Now I'm going to answer questions, and I'm seeing questions coming in. So I'm going to address those. I'm both on YouTube and I'm on Instagram. I am on here Mondays through Fridays, usually around lunchtime. I had some matters to deal with today, so I'm on a little late, but I'm still here to answer your questions. So send my vowel case 11/22/22. After 3 months, I get the I-797C fee waiver approved. So far, I didn't get anything. Other people send VAWA in the same time. Some get fingerprints or prima facie. Is that normal? So the first thing you are going to get is the receipt notice. So you don't usually get the biometrics. You don't get the prima facie all at the same time. Usually, and they sometimes it does take that long for them to process it, especially when you're asking for a fee waiver. So when you're asking for a fee waiver, it takes time for them to review the evidence to determine whether they're going to give it, and then they accept your case and issue a receipt notice that acknowledges that they've waived the fee and that your case is now being processed. After that is when you can expect to get the biometrics. Right now, we're seeing biometrics taking anywhere from a month to 3 months to come after the application time. And then after that, the prima facie takes about 3 to 6 months to come through after application period. Now, these are just estimates based on my experience as an attorney, but it doesn't mean that that's going to be the same thing for you. All right, great questions. Go ahead and put those questions in the comments. So I'm scrolling through on Instagram to see your questions. So hang tight as I go through. Is there a cost to file that? So this is the I-751 to remove the conditions on the 2-year to the 10-year. Yes, there is a cost for it, and it's a whole new application process. You should not be underestimating this process. Just like with your marriage-based process, this is a whole new application where you literally have to prove again that you do have a bona fide marriage that's continuing. Don't think A lot of people think, oh, they believed us the first time. We have a bona fide marriage. What more could they want? And they just sign the paperwork and send in their marriage certificate and whatever documents they want, required documents, and they don't think anything of it. And then they get either a notice of intent to deny or a very lengthy, nasty request for evidence. And the request for evidence will usually say you failed to meet the requirements, and it's very nerve wracking for the individual who gets it. So you want to make sure that you are proactive and that you fully understand this process and you are prepared and you submit a solid application. It is like preparing a brand new application showing that you continue to have a bona fide marriage with brand new evidence, none of that old evidence. So all fees are going to increase next month. So not all fees. For example, VAWA, the petition, I-360 petition, the T visa, the U visas are staying the same. Some of them are not going to be substantial increases. They do have a whole chart to show there are many forms. Most of the forms, there's going to be an increase in some way or the other, though. When it comes on to the most common ones that I work with is the adjustment of status, where you're staying here and you're getting the green card. That one is going from 1,225 to 1,750. So that is a big jump. And then there's also the petition, family-based petition. That's going from 535 into the 700. So those are significant jumps. Thanks so much, Alex Wandon, for the follow. I appreciate it. All right, still scrolling through. Go ahead, keep putting those questions in the comments. I'm keeping an eye on YouTube and I'm keeping scrolling through the chat on Instagram. Can I get married to a Puerto Rican and get my status in America? So, yes, so Puerto Ricans are able to sponsor their spouses to reside in the United States. Has it been finalized when the fees are going to raise? So the proposal is, I think the proposal goes until March 6th, and after that, they're going to publish the final rule. So, but it's very likely that what you're seeing on that chart is going to be reality soon. Do you have to remove the conditions or just go ahead to citizenship? Absolutely not. You have to remove the conditions first. So no individual who has gotten permanent residence, unless you are a child under 18 who's derived it from their parent, no other individual who just has a permanent residence through marriage is going to be able to just skip all of the rest of the removal of conditions and jump straight to citizenship. you're always going to have to be approved for the removal of conditions first and then move on to citizenship. What has happened is that when the applications to remove conditions are pending so long that while it's pending, if the 3 year mark passes and you're still married to your US citizen spouse, or you're applying through VAWA, for example, based on mistreatment by a US citizen spouse, you can go ahead and apply for US citizenship while the application is pending. Doesn't mean that they're going to just jump straight to the citizenship application granted, but what it does mean is that when they are reviewing the removal of conditions, they may very well just have a joint interview where they review the removal of conditions, and then if all being well, they approve it, they jump straight into the citizenship process right then and there. So that has happened. However, it's going to depend on what does that removal of conditions application look like. Do they have additional questions or doubts? If they do, then it could complicate the citizenship process. All right, great questions. Keep putting those questions in the comments. How long after applying for asylum work permit do you get the actual permit in the mail? The permit has applied for after the 150 days, so you don't qualify to have it issued until 180 days. But keep in mind that they're not you're not entitled to just get it on the 180-day mark. They're ranging from anywhere from 6 months to over a year to get these work permits. But it just means that you don't qualify to get it until 180 days after you've applied, even though you can start applying for it. All right, keep putting those questions in the comments while I'm here. Go ahead, put those questions in the comments. All right, so while I wait for some more questions to come in, what I'm going to do is tell you exactly how to get in touch with me. Okay, so I do see one here. So when you've gotten a VAWA approved, what's next? How many approvals should you should get? So the the when the VAWA is approved, it then automatically moves to permanent residence, or you can apply for permanent residence through adjustment of status. With the approvals, how many should you get? You know, I've gotten many approvals. However, in regards to you, I'm not sure whether you're asking in regards to you. If you get approved for VAWA, then you'll move on to the permanent residence. It's not guaranteed to be approved until they schedule the interview or until they review your application. But in regards to my results, I have had great success for my clients. And that is why I come on here every day to make you know about this form of relief, because I have helped many clients to navigate that process successfully. Why does it take Jamaica so long to get police clearance? Yeah, so I do know it takes some weeks. So, just to get the appointment, I know they were requiring an appointment at one time, but it is taking about 4 weeks, and you'll have to check with them. Can a citizen file all forms for a family that came from Jamaica and they decide not to go back but still in status but over 21? So, no. The short answer is no. They cannot come here and overstay if they're already 21 or over and a US citizen parent is sponsoring them. And it really just has to be, and it's going to depend, right? Because you said here, can a citizen file for the family? It's going to depend on who in the family is being filed for. Is it a parent filing for a child? So if it's the parent filing for a child who is over 21, they should not under any circumstance overstay, right? I mean, it has to be beyond their control to be in that situation because it's not necessarily going to be advantageous. If they overstay, it means that they may very well be stuck here for years. Right now, the process for parents to sponsor their children who are 21 and over is 5 to 7 years. And that means that they'll be stuck here without any status, any ability to work, no way to fix their status, no way to file for adjustment of status for 5 to 7 years. Then, on top of that, there's a question of whether they can get forgiveness for the overstay, which you wouldn't be able to contend with until about the 6th or 7th year. So in those cases where the relative is outside of the United States and the parent wants to sponsor the children who are 21 and over, even though it's a very long wait, it doesn't do them much justice to come here and overstay because it just sabotages the entire process. Can a United States parent petition for an undocumented unmarried child um, over age of 21? So I just mentioned that no, they can petition for them, absolutely, but petitioning for them is not going to get the green card. The petition that the United States citizen parent files is to state that you have a qualifying relationship and you would like them to get permanent residence. But if they're in the United States and they're undocumented, then the only way to get the green card at that point would be to do adjustment of status or to get a waiver. If the waiver is approved, that's forgiveness for the overstay. They have to go back to their country and then do the interview at the country that they're from based on that waiver, based on the forgiveness. But those are the two ways, and there's no shortcut here. There's no shortcut. What I usually say to people is that, and of course, always make sure you schedule a consultation with me so we can talk about it to see if it makes sense for you. But I often say if the parent can file a petition, they you can go ahead and move forward with that, and then look at, and it stays there, and it stays there pending. It doesn't do anything, doesn't make a difference. But if the child's circumstances never change and that's the only way that they're going to be able to get status, then maybe at the 5th or 6th year or 7th year, they can then explore the waiver option and go to the embassy for the interview and get their permanent residence. So it's sort of creating a plan B for yourself, right? If say you have, there may be other things that come up, right? So if their child is, they're young enough or they've been here and they're here for a long time, they meet somebody, they get married and they can fix their status that way, great. But if that never happens, then they can always look to the petition to see if that can work out for them. So in the meantime, while they're looking at other options, they can always have this petition to fall back on. However, keep in mind that whether filing it or not is going to make sense. It's going to come down to your particular circumstances and what your plans are in the future. Like a daughter mom filing for a daughter. So, yep, I explained that. Can I get back travel documents after being deported more than 10 years for weed? So, it's going to depend on how much. If you were deported, I have a hunch here that it was a large amount of marijuana. Unfortunately, even though marijuana is becoming legalized in many states, that is not the case under federal law, and it is not the case under immigration law. If they still find that in your system during the medical, if they still find that you were trafficking the weed or selling the weed, or you had an amount that's larger than a couple of ounces, then you could very well be categorized as a drug trafficker and banned for life. So, it's going to depend on how much here to see if you qualify for a waiver. There is a waiver if you have a couple of um, ounces, but if you have a large amount, then it's unlikely that a waiver is available in this case. Hi, now, if you're married for 6 years with a US citizen and then divorced, can you do your citizenship still in 3 years? So if you are trying to take advantage of the 3 years, you have to be married to the citizen. You have to be in marital union with the US citizen. Otherwise, you have to wait those 5 years. Uh, Can I get back? Okay, let's see. I'm waiting for an interview date from last year, July. How long will it take to get that interview? So with my clients, I'm seeing anywhere from a few months to up to a year to get that interview. So it's, in last July, it's not, it's still a couple of months. But at this point, you just have to wait for it. My visa was revoked in 2020. How will this affect my petition that was done by my mom in 2018? I'm a married son. So if you're the married son of a US citizen, it's taking 12 years. So you can do the math and to estimate. I'm a citizen. I filed for my husband. It was approved. My husband is waiting for his appointment for police clearance. My husband is in the military. Do you have an idea how long will everything will take? So, I don't know. I see you're a citizen. Your husband got approved, and then the husband is in the military. Is the husband in the military in the country he's in? So I'm a little confused here. But what I will say is there's not no necess I mean, there are benefits to having a spouse in the military. However, it wouldn't apply to this situation. The interview, waiting for the interview, it sounds like you're waiting for the police clearance. Um, Even though the petition has been approved, you still probably have a ways to go. When it gets to the National Visa Center, they process all your paperwork. Once they say that you're documentarily qualified, then they're going to go ahead and they're going to put you in the wait list for the interview. I'm seeing the wait times for interviews ranging around the world anywhere from 3 months to even over a year. How much is your consultation fee? It's $150 for up to an hour. And we can talk more about your situation and just get started to help you to, reach your goals. All right. What are the benefits of having a spouse in the military? So, one benefit is that there's something called parole in place, right? If you enter the country without permission and you do have a military spouse, you could fix your status by getting what's called parole in place. So, we submit a request to the embassy, I mean, not the embassy, the USCIS office in the location where my clients live, and then they will issue it's a parole in place, basically fixing the situation of the illegal entry that not only provides them the ability to get a work permit and to know that they are no longer accruing unlawful presence here, and they can use that to then apply for permanent residence through adjustment of status. Now, the reason this is helpful is because when you've entered the country without permission and you've not been paroled, you have no proof of legal entry, then it means that you are not eligible for adjustment of status. But the parole in place, so for spouses of US citizen military members, means that they're able to fix that, to get the parole in place to show that that illegal entry has been fixed. What if he is the one who divorced you when you got your green card 1 year? It doesn't matter if you're divorced. If you're divorced, you're going to have to wait those 5 years. So I don't do so with Canada, if you get advance parole to Canada, there are different considerations. Are you going through adjustmental status to get a travel document, and do you have the ability to enter Canada with the advance parole? You may need a visa in addition to the advance parole, or if you're Canadian already, that's no problem. But you have to also make sure you have the papers to enter Canada as well. All right, that's going to be it for me. Thanks so much for your time. I will be back tomorrow to bring a topic, and then you can bring your questions and we can talk it through. All right. Have a great one. If you would like to get in touch with me, go ahead and schedule a consultation. That's how we start. I want to make sure you qualify. Do that you'll see in the description of this video on YouTube, on Facebook, you'll see everything you need. On Instagram, you can go ahead and look at my videos, go to the profile page, and you'll have all the information there to schedule your own appointment or call the office to get some help. Scheduling coordinators are available to assist you. All right, have a good one. Bye bye.